If your spouse passes away, you cannot sell their house because you do not own 100% of their property. And so the way it's going to work is when you both are alive and you co-own that property, you each own 50-50 of that property. And so when one of you passes away, the half of the property of that individual is going to be inside of their estate. And so the individual who's alive, they will have half of the ownership. The individual who passed away, their estate owns the other half of that property. And so when you go to sell the property, you only own half of that property. So you cannot sell that full property. So when it goes into the title, they're pulling all the information. They're going to say, hey, this person is trying to sell it. They only own half the property. The estate owns the other half of the property. And so what we have to do is go through the probate process to get that property out of the estate and into the seller's name completely. And at that point, once the probate process is over, in theory, they would own 100% of that property. Depending on how the will set up, the intestate laws, etc., you may not even get 100% ownership of that property. But it's best to do the probate process as soon as you possibly can when someone passes away. That way you get all the assets out of the estate and into the beneficiary's names. Then you can figure out how to manage those assets and potentially sell that property.